So initially, Air Canada was fighting tooth and nail to prevent me from speaking for the passengers. Those arguments, however, were turned down by Justice Duncan in a one-line letter. There is something else which is unique about this case, which is that normally only a lawyer can represent the party in a Nova Scotia Supreme Court. Mm-hmm. And in this case, we have been granted special permission by Justice Duncan to allow me to speak for the passengers, which was great because it involves some complex legal questions. And we were up against a very capable lawyer with many years of experience. So it was important that the passengers will have someone speak from their perspective who is able to address some of the legal arguments and able to bring authorities.
Right. I think initially, or probably still, Air Canada's lawyer didn't like that you were speaking on behalf of the claimant, right?
Initially, Air Canada was fighting tooth and nail to prevent me from speaking for the passengers. Those arguments, however, were turned down by Justice Duncan in a one-line letter. His lordship advised the parties that he would grant our motion to allow me to speak on behalf of the passengers.
Mm-hmm. Right. So I
guess you should perhaps do a step back and talk about what the case was about.
Right, sure.
The case starts from 2016 December, where Nicole Paine, young mother with two 2-month-old twins and a 3-year-old daughter, and her mother accompanying them, presented herself at Vancouver Airport on time for her flight. When they reached the check-in counter, which still happened within time, the check-in agent just said after some time, "Your flight has been closed." The agent was confused. The fact is that they were on time, and that is also what the small claims court found. The issue here is whether they are owed denied boarding compensation in accordance with Air Canada's terms and conditions. My argument was and is that what happened is an involuntary denied boarding, and Air Canada's rules with respect to denied boarding expand to this situation. Air Canada argued that their denied boarding rules apply only if the flight is actually oversold.
Right. So that I tried to read the cases, the presentation by yourself and by Air Canada a little bit. So it on this note is down to, if I get the rule number correctly, it's 245 section E, right? And the argument is you cannot go straight to section E, and you have to look at the overall condition, which is the oversold assumption. And
well, it was not phrased as oversold. It was phrased as that there are more tickets than actual seats available. Mm-hmm. Now, when you look at the exceptions to the rule, and we do know that the exception proves the rule, the exception also talks about a situation where the passenger cannot be accommodated on the flight because of weight and balance restriction, not because the flight is oversold. So this boils down to a great extent to the difference between, are we talking about physical seats not being available on the flight or logical seats not being available on the flight? You can have a situation where you physically have seats on the aircraft, but those seats cannot be used because the seatbelt is broken, because there are no sufficient crew members, because of other reasons. And the question is, do those things fall under the rule? And I would submit that yes, they do fall under the rule, and the only exception is when it's a small aircraft and it's due to safety reasons, which is carved out. So my argument was that if Air Canada does not staff its counters correctly, or for any other reason does not allow passengers to go through the process necessary for them to actually occupy the seat, then that seat is actually illusory. It is not a really available seat. It's only an illusory, it's an imaginary available seats.
Right. Your argument is, or the fact of the case is, I think it's down to one agent, and the other agents were in a meeting, and it's kind of like, well, lay person like myself, looking at the situation, it's like, well, if they close if they don't have the sufficient number of agents to handle the situation, that would cause delay, and that's part of I guess what you're arguing too. Right?
Exactly. The Air Canada's counter argument is that the passenger can still seek compensation under negligence or under contract law, but not under the denied boarding compensation rule. The difficulty with that position, from my perspective as a consumer advocate, is that it means that each time that this happens, and it's not an uncommon situation, unfortunately, then passengers would have to go through a major court process instead of just have a readily available standardized amount of compensation. So it defeats the consumer protection purpose, which is the purpose of the whole legislative scheme.
Right.
This is the tariff system is not kind of not an isolated system of contracts and rules. It is part of a legislative scheme, of a regulatory scheme that is meant to simplify the relationship between passengers and airlines. There have to be clear rules, a bright line rule, and that's what I propose. If a passenger shows up, they are not allowed to board for whatever reason outside of their control, then it's involuntary denied boarding and compensation is owed. Air Canada wants to superimpose on it the condition that the flight also had to be overbooked. And how would a passenger be able to prove that the flight is overbooked? How do you know? How do you have access to the record that the flight was overbooked?
Right. I mean, of course, if we go back, I guess, a few years now, that's this $200, $400, $800 compensation was, I guess, due to one of your cases, and then that leads to this compensation. But again, like that, you having that as a context and having that, I mean, at least that's what Air Canada's argue, under 245, right on the definition or whatever, that those are overbooking and whatnot, the words that are being defined, right? And I think the argument is, hey, this section, you can't go straight to E, and then, but you are, I guess, in a sense, trying to expand that. Am I right to say that?
No, I'm asking just the court to read the contract written by Air Canada against Air Canada. That's one of the principles of contract law, and that you, when you have a contract prepared by one party and standard form contract, and if there's any ambiguity, you read against the party who prepared the contract.
Right. Again, I read maybe a little bit too much. So in this case, it's a one-sided contract where Air Canada is the sole party that drafts up the contract. It's for flyers like myself or the claimants in this case. It's a take it or leave it situation. It's not like you can negotiate that term or this term, and no, well, you fly or not fly, you buy or not buy the ticket. Right. Right. So going back to what we previously talked about, I guess in the general context of having a small claim court case and now appealing the case, in a sense, you're trying to, I guess, set precedents, right? I mean, you're going to create...
I would like to fix this problem. This problem has been happening for a number of people in various scenarios, and this should be fixed once and for all. So I'm trying to fix this situation. One precedent which already has been set, and I'm very pleased about, is that the court permitted me to represent the passenger. That in and on its own, I would view as a victory. As to what happens next, it is going to be an interesting situation. There are two possibilities. Either the judge says, well, you are right, and Air Canada has to pay compensation to the passenger as per the denied boarding compensation rule, or the judge is going to say, well, you are not right. This is not covered by it, in which case I would want to go back to the Canadian Transportation Agency and have Rule 245 fixed. Because the Canadian Transportation Agency did rule in the past that in such situations where a passenger shows up at the airport and present themselves for check-in and they're not allowed to, nevertheless not allowed to fly, the airline has to pay denied boarding compensation even if the flight is not overbooked. So there is already a precedent from the Canadian Transportation Agency dealing with such a situation.
Was it the Sunwing case, or was it?
It's a Navras versus Sunwing, yes.
Any idea when will this case be decided? Any indication from the judges, or weeks or months, or?
He was one judge, actually. So this was a single judge in this case. And Justice Duncan indicated that he would be traveling for the next 6 weeks. So we are probably looking at end of February, although His Lordship may release a decision as he's traveling. We don't know. We really don't know that. So we shall see. We shall see how when His Lordship has the time to articulate reasons and to explain why we are right or why we are wrong. And I will look forward to it. I was very pleased that it was a very good hearing. I could see that His Lordship was interested in both sides' arguments. And he was very concerned as to making the right decision and ensuring that this doesn't shut the door for passengers, because it's quite clear something went wrong here, fundamentally wrong. So it's just a question of what will be the forum to address it and how such issues will be addressed in the future.